Every holiday shopper's got a list, but Ross shoppers, you've got a mission. Like a gift run that turns into a disco snow globe, throw pillows, and PJs for the whole family, dog included. At Ross, holiday magic isn't about spending more, it's about giving more for less. Ross, work your magic.
You can't solve every case for your kids, but with Greenlight, they'll have the instincts and the money skills to stay out of trouble. With a Greenlight debit card and money app, parents can monitor spending and teach financial responsibility. It's an easy way to guide kids as they grow, from earning allowance and tracking chores to learning how to save and even invest. Start your risk-free Greenlight trial today at greenlight.com/Wondery. That's greenlight.com/Wondery.
Hey, fans of freedom and open discussion, I'm heading over to Substack, and there's an ad-free audio and video version of The Adam Carolla Show that's going to be waiting there. In the near future, you'll even be able to watch ACS Live, unedited, as we record it, participate in the show via live chat. That'll be coming up very soon. You'll also get an ad-free version of the Adam Carolla and Dr. Drew Show. You'll also get an exclusive to my new podcast, Beat It Out, where I share unpolished ideas with my comedian buddies. The first series of episodes is going to be Jay Moore. You'll get all this and more for the low, low price of $9 a month. A pittance for all we're going to bring you. Subscribe now at adamcarolla.com/Substack, and I'll see all of you in our new speakeasy called Substack.
I'm Alice.
And I'm Brett.
And this is The Prosecutor's Legal Briefs. Welcome back to The Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my suppressed co-host, Brett.
It's true, Alice. In so many ways.
You're really not. You're the least suppressed person
hours.
I know.
I need a couch to lay on. It's true.
Oh, you are the least suppressed person. But you, as a prosecutor, Brett, deal with suppression motions all the time with basically every single case where there's any evidence recovered. Someone wants to suppress the evidence because guess what? If you're trying to charge someone with felon in possession and you can suppress the gun, you got no case, right?
I literally have a suppression hearing tomorrow.
There you go.
Yeah, it happens all the time. And with varying levels of success, I mean, every now and then. I think one thing that's worth discussing just before we get into this conversation about this particular suppression motion in this particular case. So one thing we always try to educate everybody on is avoiding sort of the sensationalism of true crime news and reporting. And you see this in a lot of the cases that we have covered. Whenever someone files a suppression motion, a Frank's motion, I mean, whatever various types of motion they're filing, it's always presented as this bombshell, this shocking event that could bring down the whole case. As if, man, the defense attorneys only file these kind of things if they're absolutely certain they're going to succeed. Whatever is the state going to do? Will there be justice in this case? I mean, just all the breathless commentary, right? And I think it is important to know exactly what Alice just said. These are incredibly common and really occur in any case where there's even arguable claims for suppression for a couple reasons. Number one, because oftentimes it's the entire case. You either get the evidence suppressed or you lose. You're just going to plead guilty. And the second thing that I think is worth remembering, this is always an evolving area of the law. And so if you have a good argument, challenge it. That way it's preserved. Even if you lose, you go to trial, you lose the trial. Maybe by then the Supreme Court said, you know what, there's this new standard. And all of a sudden, you know, you preserve the issue and you can bring it later. So just know that these are not uncommon. And a lot, no matter what case it is, a lot of the breathless reporting you see is way overblown.
I think that's exactly right. The fact, and we've said this in other cases, this is a very common, you should have a good faith basis to bring this argument, but these are so common, especially, like Brett said, if there's any sort of a seizure of any type of evidence. And in the case we're about to talk about with Luigi Mangione, that's going to be the case. When my example just now was the felon in possession. If you find the gun after a traffic stop, almost 100%, that fact pattern right there, there's going to probably be a suppression motion because there is a search incident to that traffic stop that recovered the firearm that led to the federal charge. And therefore, that is going to be the whole case. And like Brett said, it is not cut and dry. We know that we have these, Fourth Amendment rights. We have these Fifth Amendment rights. But if you've read the Constitution, it is not a science equation, right? It is not a math equation. It does not say you are allowed to be stopped for this many minutes and you are able to be searched under these 25 circumstances and that's it. That's not what it is. We live in a common law system. These are also fact dependent cases, and that's the key. Every single criminal case and every single suppression motion is going to be incredibly fact dependent. That it's not going to be, okay, because that case came out this way, that was suppressed, that means our case will. You can make analogies, but these are going to be incredibly fact bound. And we'll go through the facts of this particular case and what is going into the suppression motion at issue here.
Yeah, let's do it. So, as some of you know, as you record this, we've just had the first in a series of hearings in the Mangione case. The prosecution yesterday, they presented a lot of surveillance video, some body cam, 911 call. It was really the first time we saw a lot of the evidence that they're going to have in a formal way. And this is all run up to a motion to suppress the defense has filed. And it is a motion essentially seeks to suppress pre-Miranda statements made by Mangione when he was arrested at a McDonald's, evidence seized from his backpack that he had with him at that time, which includes a gun, journal, manifesto, electronics, really the whole case. I mean, there's a reason they're filing a motion to suppress. Someone in the chat asked if there's a downside. No, there's not. The only downside to filing a motion to suppress is in a typical case when you're eventually going to have to come to the table and ask the prosecutor to be lenient and make a good deal with you. If you make them do a lot of extra work in a frivolous suppression hearing, they may say, no, your acceptance of responsibility has been very low in this case, and so we're not giving you a good deal. So that's in a typical case. A suppression hearing maybe has a downside. Case like this, nothing they do has a downside. They're going to do everything they can. The man is facing either life without parole or the death penalty. So they're going to be throwing everything at the wall, which is not to say this is not a legitimate motion to suppress. I mean, this is not a frivolous motion. These, as we said, are real things, Miranda rights, statements that are made. And this is a gray area in the law because there is a moment where you have to be Mirandized. But as Alice said, it's not a science equation. It's not 100% certain. And there's always some conversation beforehand. And we're going to talk about that. And really, I will say this. If the defense loses this motion, really, he should plead guilty. I don't know that he will. I don't know that it's in his character or makeup, given his sort of political whatevers he's trying to accomplish here. Maybe he wants to go to trial. But this really, in a lot of ways, will be the case. So that's one reason it's worth following. And this is a Fifth and Fourth Amendment claim. And they are presenting these arguments, the Miranda argument and the evidentiary argument, as their reason for suppression. Now, one thing I want to clarify right off the bat before we really get into this, I've already seen people misstate the issue and say things like, since they searched his backpack before they Mirandized him, the evidence can be thrown out. No, it has nothing to do with it. The Miranda is all about statements. The search of the backpack is a completely separate issue under a separate clause of the Constitution, separate amendment of the Constitution. So just know that as we go through this, these are two attacks on two separate pieces of evidence. And even if the defense is successful on one, doesn't mean they'll be successful on the other. And even if they're successful to some extent, doesn't mean everything gets thrown out.
Yeah, the conflating of those two different arguments is classic I don't think intentional misreporting, but misunderstanding of what your constitutional rights are. So let's break down those two different challenges here. Let's talk about the Miranda statements. So this stems from, of course, the Fifth Amendment of the Constitution against self-incrimination, right? When you say, or when you hear on TV, someone says, I plead the Fifth, what they're actually saying is I plead my constitutional rights under the Fifth Amendment not to self-incriminate. So you don't have to testify against yourself. The Miranda rights that you now hear, Miranda rights, if you remember them from TV, you have the right to remain silent. Anything that you say can and will be used against you. You have a right to attorney. You will be an appointed attorney if you cannot afford attorney. You guys know all these things. That actually does not appear in the Fifth Amendment. It appears nowhere in the Constitution. In fact, this is what we meant when we said this is a developing area of law. The Miranda rights came from a case before the Supreme Court, Miranda versus Arizona, in 1966, where the Supreme Court is looking at the Fifth Amendment and says the Fifth Amendment, to protect your right against self-incrimination, says that you have to be made aware of those rights before you give these types of statements. And that's where the Miranda warnings come from.
And I would just note, if you want to learn more, early Legal Briefs episode on Miranda versus Arizona. So go check it out.
And okay, so this is where the gray area starts. We know that there are these Miranda warnings, right? Now it just like flows off the tongue, for even cartoons have it, right? We know what that means. But when do you need to be Mirandized? There is not a bright line. There is not a number of seconds that happens, because these are all fact dependent. And so the defense is arguing that Mangione was questioned without Miranda warnings. Now, if they're right about that, then, and he was supposed to be given his Miranda warnings and wasn't, then there is an argument that everything he says when he had not been properly noticed of his constitutional rights cannot be used against him. If the prosecution succeeds and says, no, Miranda warnings were not warranted at that point, because the police don't have to just walk up to anyone on the side of the street. Let's say they saw a child walk off. They don't need to Mirandize every witness along the way before they're like, did you see a child? That's not required, because first of all, that would completely impede the police from being able to do their jobs. And the Miranda rights are supposed to be invoked essentially when you're like in custody and you are being asked and what you say can be used against you.
Yeah, I mean, think of it this way. How many of you have been pulled over by the police?
Oh,
did they give you their Miranda warnings?
No.
Because you're not in custody, where that would be something that they would have to do in order to use anything that you say in that circumstance against you, which is interesting because you're not free to go. You were pulled over. You're under their control.
You're
if you drive off, that's a crime.
Right.
But you still haven't crossed that threshold where they have to give you your Miranda warnings.
And so you can see how there is a gray area here, because the facts of this case is that Luigi was at a McDonald's, which is a place that he's allowed to sit, right? My example of the bystander standing on the side of the road and the police walk by saying, have you seen a kid? They're just out and about doing their own thing. He's sitting at a McDonald's and the police start talking to him. He doesn't have to be Mirandized the second the police see him. That's not when he needs to be Mirandized. But at some point in their conversation, there probably is a point in which he should be Mirandized. But again, there's not that bright line rule. So what the prosecution and the defense are arguing about is when that Miranda warning had to have been given, when he was in custody. So if you're sitting at a McDonald's and the police walk in, can you leave? Of course you can, right? I mean, I don't do it all the time, but like if a bunch of police come into like a McDonald's I'm in, I'm about to like get out of Dodge because I don't know what's happening over there, right? So of course you can leave. But let's say you are sitting in the back of a cop car because they're like, let me talk to you for a second, and it's a little loud out here. Why don't let's step out of the McDonald's. Why don't you step in the back of my car and we'll talk for a little bit. I'm going to close the door. It locks so you can't get out because it's a cop car. I'm going to sit in the front and there's the divider. And we're just going to talk. We're just going to have a little conversation. Is that custody? Are you free to leave? I think there's a pretty good argument that you can't leave. You're in the back of a cop car. You can't open the door because it's locked and you're being talked to through a gate. I would argue that you would in fact need your Miranda rights at that point. So that's those are the extremes that I'm giving you there.
Another one. What if you're in handcuffs? Does that mean you have to have your Miranda rights read to you? Because the answer is it depends. Just because you're in handcuffs doesn't mean that you're under arrest for purposes of Miranda. You know, if you guys don't watch On Patrol Live, it's worth watching just because you can pick up on a lot of this stuff just watching an episode of that. Because a lot of times the police will get someone out of the car, they'll put handcuffs on them, and they'll say, "You're not under arrest. I'm just detaining you. This is just for officer safety. There's only one of me and there's 5 of you, so I'm going to go ahead and put handcuffs on you for officer safety." Most likely, no need to read that person Miranda. Anything they say can and will be used against them, even though they don't know it, right? Until he says, you say, "Yeah, man, I got a pound of marijuana in the back. You're right." You know, at that point, he's going to arrest you. Then he's going to read you your Miranda rights. So this is a much more nuanced area of the law than people realize. That's the first thing. Then there's the Fourth Amendment, which honestly is a more interesting question because, frankly, the Miranda stuff they're attacking, it's not frivolous, but it's almost frivolous.
Hey, by the way, here's why it's like kind of low bar. First of all, they don't need his statements. They have him on security surveillance, right? They don't even need his words, but they know it's him by face. Of course, they could be wrong, but they're pretty sure of it. And basically, the first words out of his mouth, they know to be false. And so the second you tell a lie and there's evasion, there's false identity, there's more than probable cause there for continuing that conversation. That's why it's not frivolous, but that's an easy argument for the prosecution to win because it's such a clear case that he was already lying. The first words out of his mouth, "I'm homeless." They knew he was not homeless. I mean, he was in like a nice blazer and a button down. So even if they didn't know who he was, they had probable cause to believe that he was lying, even if they didn't know this was Luigi Mangione, based on the way he looked, based on officer experience of someone who typically is homeless or not homeless or saying they're homeless in order to evade detection. That's why that argument, I just wanted to break it down, why it's an easy argument for the prosecution to succeed on. This episode is brought to you by Progressive Insurance. Fiscally responsible, financial geniuses, monetary magicians. These are things people say about drivers who switch their car insurance to Progressive and save hundreds. Because Progressive offers discounts for paying in full, owning a home, and more. Plus, you can count on their great customer service to help you when you need it. So your dollar goes a long way.
Visit Progressive.com to see if you could save on car insurance. Progressive Casualty Insurance Company and affiliates. Potential savings will vary. Not available in all states or situations.
Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
And let's just be clear, they don't need any cause at all to walk up to him and talk to him. None. They don't, they can ask him questions, he can answer them or not answer them. A cop can walk up to you for no reason and be like, "Hey man, what's your name? You look familiar." That's fine. He doesn't need any reason to do that, whether you look familiar or not. Now, if you are detained, if the police have probable cause to hold you and they ask you your name, you actually have to tell them your name. That's one of the things that's like a lot of people don't realize. And if you don't tell them your name, you're going to get arrested because you just can't do that. And that's one of the things that we've sort of decided on is sort of an exception to all this. Like you have to identify yourself. So just you're going to see this if you pay attention to this hearing, you watch this. This is going to be a pretty low bar to clear for the prosecution. The search is much more interesting. And there's a lot of case law on this. And this is the Fourth Amendment, unlawful search and seizure. So the defense is basically saying, look, this is a warrantless search of his backpack. Now, typically speaking, warrantless searches of anything are presumptively unconstitutional and invalid. That's the starting position is always that. And the government has to prove that there's an exception to the warrant requirement that allows you to do that search, right? If you have a warrant, you can search anything. If you don't, you have to show a reason why. And the defense is saying, look, all of those exceptions that you could have, search incident to arrest, an exigency situation, an inventory search before you tow a car. Like, these are all things that are an exception. The automobile exception. If you have probable cause to believe there's evidence of a crime in an automobile because it's mobile, you can search it without a search warrant. These are all sort of exceptions. They're saying, look, none of these applied. And since none of these applied, they should have gotten a search warrant before they searched the backpack. Even if they had probable cause to arrest him, they couldn't search the backpack. They didn't get a warrant. Therefore, everything in the backpack should be excluded as fruit of the poisonous tree. And this is going to be the general argument that the defense is going to make, and it's going to be incumbent on the prosecution to show, no, there was an exception, a valid exception, that allows us to look in that backpack when we did.
So, what's the prosecution going to say? Of course, with a suppression motion, the leading motion is going to be brought by the defense. They're going to bring the arguments. They say these are pre-Miranda statements that should be thrown out, and this is an illegal search. So, fruit of the poisonous tree. They bring the arguments, the prosecution has to respond. So the prosecution is going to say that this search was justified because of probable cause for the arrest. He had shot a man point blank in the back of the head, caught on surveillance, and was on the run. So there are all these I think there's search incident to an arrest. I think there's exigency. He was clearly evading, right? When they asked him who he was, he said he was homeless, or they asked him if he'd been in New York where the murder happened. He's like, no, not at all. Things that they knew to be false. So they already knew he's a dangerous person. He literally just walked up to a man and shot him in the back of the head, right? And he still has the weapon, presumably. And in fact, he did. So there is danger to the public as well. They're going to say there's absolutely probable cause in order to justify this arrest and the search. And it's a strong argument because of all of the things I just said.
It is a strong argument. And we are going to talk about some of the Supreme Court cases that will be raised in this that sort of lay this out. So we will start with a case called United States versus Robinson. It's from 1973 when a lot of this was developing, 60s and 70s. You know, you got Miranda, you got these kind of cases coming through, right to privacy, right to search, warrants, everything. So in this case, basically, you had someone who was arrested. And after the arrest, the police were sort of patting them down and sort of a Terry type thing. We've talked about Terry stops before. And while they're doing it, find a cigarette pack. And they take the cigarette pack and they open it up and look inside it. And there, inside the cigarette pack, is some heroin. Right? So they find heroin. And so the argument was, look, you had the right to arrest me. You might even have had the right to seize the cigarette pack. But if you wanted to search it, if you wanted to look what was inside of my property, you needed a warrant. And this is what the Supreme Court said about that. Since it is the fact of custodial arrest which gives rise to the authority to search, it is of no moment that Jinks, who I believe is the police officer, did not indicate any subjective fear of the respondent or that he did not himself suspect that the respondent was armed. Having in the course of a lawful search come upon the crumpled package of cigarettes, he was entitled to inspect it. And when his inspection revealed the heroin capsules, he was entitled to seize them as fruits, instrumentalities, or contraband probative of criminal conduct. So essentially, this is the search incident to arrest exception to the warrant requirement. It is a very common sense exception. The idea that when you arrest someone, the stuff that is generally on them and around them, you should be able to search as part of your arrest. And this rule, in this case, it's a cigarette pack, but it's been extended to other things, such as backpacks. If they are within the arrestee's immediate control, if they potentially pose a safety risk, such as maybe they have weapons inside of them, if they pose some sort of evidence destruction risk for some reason, you know, maybe there's smoke coming out of it and you want to like get it open and put the fire out or whatever, the officers may search them incident to that arrest. And essentially, one of the arguments that's going to be made here is Mangione is arrested. The backpack is right there. This is a search incident to arrest. No big deal. Happens every day.
So, seems like that's pretty clear, right? Well, this rule is not unlimited. In United States versus Chadwick, a 1977 Supreme Court case, it places a constitutional limit on Robinson. So once the police have removed a container from an arrestee's immediate control and they have exclusive possession of it, that search incident to an arrest rationale no longer applies. And then at that point, a warrant is required.
And this is an example of bad facts make bad law, because Robinson made tons of sense. But then the police started to kind of abuse it. You know, they basically would be like, and in this case, it was a Foot Locker. They were like, well, we arrested the guy and took him to jail, and there's a Foot Locker that belongs to him. Well, since we arrested him, we can search this, right? I mean, that's the rule. And they searched the Foot Locker, and then the Supreme Court was like, no, that's not what we meant. We didn't mean you could just search anything belonging to the person because you happen to arrest them. There are going to be circumstances in which you need a warrant. The problem is, in real life situations, what exactly do these two rules mean when they're together? You know, what does it mean to be in control, like, of something or able to reach something? Is it, we have Mangione, but we hadn't put the cuffs on him yet, so we can search the backpack? Oh, shoot, the cuffs are on him. Stop, don't search it, right? Like, it's this, that feels weird. And frankly, the Supreme Court and a lot of courts have sort of grappled with that and been like, well, you know, you never know. He could get away. He could get into it somehow, you know, but maybe if he's in cuffs in the back of the car, then you couldn't search it, you know, because could he really get away? And you have all of this sort of stuff and these individual fact patterns that make what seemed like a clear rule very muddy.
And that exact kind of fact pattern came before the Supreme Court in Arizona versus Gant. In Gant, the police arrested Rodney Gant for driving with a suspended license. So he was handcuffed and he was locked in the back of that patrol car. Clearly, he wasn't able to access his vehicle, right? It's not in his custody. He can't reach over and grab a gun from there now. So the officers searched his car and they found cocaine in a jacket in the back seat. The state argued that Belton allowed a full search of the passenger compartment of a car whenever an occupant was arrested, regardless of whether the arrestee could reach the car, which in this case, Gant couldn't. Now, the Supreme Court disagreed. The court held that a vehicle search incident to arrest is lawful only in two narrow circumstances: when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search, or when it's reasonable to believe the vehicle contains evidence relevant to the offense of arrest.
So he had been arrested for like disorderly conduct. And that was one of the problems. So they were like, they arrested him for disorderly conduct, then they searched the whole car, then they found drugs and guns or whatever, cocaine. And the Supreme Court were like, well, so we're going to have these narrow exceptions, but they're actually really broad, especially the second one.
The second one is like, you know, it could be relevant.
And so what people have fought over ever since Arizona v. Gant came down, I think in 2004, is, does that second part apply to any search or only the search of a vehicle? Because the Supreme Court's always treated vehicles a little differently because it's a mobile thing, you know, it's
like your mobile castle. Exactly. Kind of like your home.
So it's like, you know, we want to have a little bit different standard for cars. And in some ways, the standard is more restrictive. In some ways, it's much less restrictive for police, just depending on exactly what happened. And so there's been that sort of argument. I mean, take this case. If you apply the reasoning of Arizona v. Gant to Mangione, you absolutely could search the backpack, because it absolutely was reasonable to believe that that backpack would contain evidence relevant to the offense of arrest. So whether it's narrowed to vehicles or not is a big deal. Most courts have kind of said it is. That exception is. Some courts haven't. So we're going to have to see what happens. But honestly, a lot of this is just sort of interesting legal arguments, but probably at the end of the day, not going to matter, because there's another argument that trumps basically all of this. Alice mentioned exigency earlier. Exigency means you have an overriding need to go ahead and do a search before you can get a search warrant. And the biggest reason for exigency is the safety of the public and the safety of officers. So you have a circumstance where you have this backpack next to a person who has been accused of committing a premeditated, high-profile assassination. One might say an act of terrorism. I mean, I think it may or may not qualify for that. We're going to have to see. You had someone who carried out this assassination with a ghost gun, wearing a mask. They carried a backpack. You have this backpack. They acted with precision. They obviously were trying to send a message. And because of that, An officer could reasonably fear a number of things were in that backpack. A secondary weapon, explosives. I mean, once again, this is a targeted attack. Not hard to imagine there might be something like explosives, some sort of remote triggering device, chemical agents, some sort of other kind of thing. More, 3D printed stuff. Anything that could potentially be dangerous. And the thing about this is, and it's just funny to watch people on X and Twitter and Facebook debate about this, right? Because in fact, one of the officers said, I didn't know if the guy had a bomb. I wanted to make sure. And somebody's like, well, she's not a explosives expert. Doesn't matter, right? This is an objective standard. The question is, would a reasonable officer in the situation be able to believe this thing might contain something dangerous? If that's true, that's all that matters. Doesn't matter the subjective belief, frankly. Doesn't matter what the officer was thinking. It's just an objective question. Could a backpack sitting next to a person in this circumstance pose a danger to the community? If the answer is yes, they can search it. And that is a very broad exception, and it is very difficult to overcome.
So the courts have consistently upheld the immediate searches of containers when officers can articulate a crime-specific safety concern. By the way, this articulation is something we work with our law enforcement officers a lot. Good law enforcement officers know how to articulate it. It's not making something up, but you can't just be like, I don't know,
I had a feeling.
We hear that all the time. I got a spidey sense. I'm like, oh my gosh. Okay, so tell me what that spidey sense means. Well, that spidey sense. I'm like, okay, I truly believe you have a spidey sense, but you need to articulate to me what gave you the spidey sense. It was the fact that he kept twitching and playing with his hands while he was talking to you, because you've seen thousands of people, you've taken interrogation classes, and you know that particular jittery motion is because they want to grab something in order to hurt you, something like that. You see that a lot when people are playing with their hands. They know that their gun is within reaching distance, and before they reach for it, they kind of twitch a little bit. Great, articulate that, and then you have the crime-specific safety concern. Now, some of these examples that Brett's already said that fall into this articulation of those safety concerns: terrorism, mass shootings, narcotics trafficking, gang-related hits, and crimes involving explosives. You can see why those would fall into that safety concern, of course, for officer safety, but as well as for the public. So in such cases, the courts emphasize, quote, officers need not take chances with their lives. This is really important because I think a lot of the public have lost sight of the fact that these are real life and death situations that officers have to deal with in the moment. Hindsight 2020 a lot of the times. And also easy for us to judge. I'm literally saying us as prosecutors as we're watching a body cam. It's very different when you're sitting right there trying to decide, okay, I know this man. I saw him on surveillance shoot a man in the back of the head. He's lying to me right now. He acted with immense precision and was able to get away despite being in the middle of a crowded urban area. He's gotten this far away already. He's basically evaded detection up until this point, and it was by accident that someone at the McDonald's recognized him, right? So you think, okay, this is a highly trained or at least highly sophisticated, dangerous individual who is not your run-of-the-mill, fell upon a gun, accidentally fired it in the right direction, and it killed someone. This is someone who is capable of even more damage if they are not stopped.
And look, these officers, they receive a lot of training. They receive training on crimes like this. They would know it's not uncommon for people who commit crimes like this to have things like explosives. I mean, I'm thinking we did a training recently on the New Year's Eve morning, I don't know how to describe it, attack in New Orleans, which I think y'all all remember. And the guy, ISIS person in the truck on Bourbon Street, ran a bunch of people down, shot a bunch of people, was eventually killed. Well, his plan was not to run people down and shoot them. That was just the start. That was supposed to drive them down the street to where he had left several coolers full of bombs, homemade explosives. And basically, he was killed. A police officer shot him before he could detonate those weapons. They found the detonator right next to him. I mean, he was ready to do it. He got shot before he could do it. right? I mean, that's sort of an example of that. You saw this, I mean, going all the way back to Columbine. I mean, their plan was to set off explosives, but they weren't very good at making explosives. So it's just perfectly believable that there would have been explosives in the bag. It just is. I mean, there's really no way to argue with it. And even, you might say, well, it wasn't smart to open the bag then because maybe it would be triggered to blow up. Doesn't matter. Once again, might not have been smart. That's not the point. The question is there a legitimate danger? And if there is, they can search it. If they could have called in bomb techs and put it in a bomb tech thing and x-ray it to see what was in it. I mean, let's think about that example for a second. Is there anyone who really thinks they couldn't have done that? That they couldn't have called in the bomb techs and be like, hey, we have Luigi just killed somebody. He's got a bag here. We're afraid there's a bomb in it. Come x-ray it. They come and x-ray it and they see a gun. When they x-ray it, they're like, no bombs, but there's a gun. Does anybody really think that would be a violation of his privacy or an illegal search? No, of course it wouldn't. Well, that means they could also just open the bag. There's no difference between the two. You can read Kylo if you want to hear about an example of that from the Supreme Court. So, essentially, this is an interesting intellectual exercise that's going to go on in court. He's going to lose. If he wins, he will lose on appeal. There's no way that this evidence will be suppressed. This search was perfectly reasonable. It probably was perfectly reasonable for multiple reasons. They're probably going to be able to establish exigency, public safety, officer safety, a search incident to arrest. There's just a lot of different ways they're going to be able to get at this. And so at the end of the day, like I said, great opportunity for us to discuss this. But what you're seeing, some of the talk about this is a really good way to drive ratings. If you're a 24-hour news service that needs to talk about something, and you're seeing a lot of that and a lot of this sort of like heated, over-the-top rhetoric about the sky is falling type stuff. But this is standard stuff and should be a pretty standard ruling.
So sorry to be cold water prosecutors yet again, but this way, as you're kind of following what's going on for the next couple of days, that there's nothing wrong with bringing this motion. In fact, I think they have to challenge this. Right? This is one of the arguments they need to bring, but they will lose on the merits.
And look, I mean, I occasionally write in briefs. Like I sometimes say, maybe one day this will be the law, and maybe this is the case that'll make it the law, but the law as it stands now, they lose. And maybe he takes it all the way to the Supreme Court, and the Supreme Court says, you know what? We've been way too lax on this whole search incident to arrest thing and officer safety thing. They're taking advantage of it just like they did after our 1974 case, and we're going to limit it. Maybe they'll do that here. Unlikely.
And here's a little tip. The Supreme Court might think that this would be a situation of bad facts make bad law because they would not find it on the facts of this case.
That's true. That's a good point. Yeah.
Even if they think that you would not use this case to be the vehicle in which to challenge how broad the exception is.
Yeah, that's a good point.
We got to be realists here. Well, I hope you've learned something here. And this will not be the last time I think this is in the news. And what Brett said at the beginning is very right. This is the first time we're seeing the body cam. A lot of the information is coming out for this hearing. This is going to be like a mini trial because this is where you put on a lot of the case. Obviously, it's not going into the actual murder, but this will be the meat of it, and it will be pretty much outcome determinative of what happens in this case. And that's why it's such a big deal, because likely he will lose this motion to suppress, and likely he will plead guilty, and likely there will not be a trial. In a regular type of case, this is obviously a very little p politically motivated case. Like he did this for a reason. It wasn't just he had beef with the CEO. He wanted to make like a political statement about healthcare. So maybe, but if this were any other type of criminal case, that would be the order of events. And so there likely wouldn't be a trial in which to televise. And that's why there's so much attention on this particular point of the case.
And look, if this goes to trial, we'll keep following this case. I mean, this is one that's popular. We'll sort of walk you through any of the legal wrangling that happens going forward.
It will be a fascinating case. If this went to trial, it'd be like the Redonda Vault case, except that Redonda Vault arguably didn't mean to do anything, whereas this was very premeditated. But there are kind of the larger existential questions.
There's going to be a jury nullification.
Exactly. Yeah.
If it goes to trial.
Right. So,
which I don't understand. I mean, I get in arguments with you guys about this sometimes. I don't understand. Like, whatever your political positions are, however strongly you feel about them, you don't get to walk up behind somebody and shoot them in the back of the head. You just don't get to do that. I mean, for me, this is an easy one, and I don't know why it's always like, yeah, but healthcare. Like, no. We never get to the yeah, but healthcare. You just don't get to do that. You don't get to shoot people in the back of the head. So, like, for me, this one's easy, but obviously, I don't know that I'm in the minority, but there's a very vocal minority who feels that this case is bigger than Luigi Mangione, and it doesn't hurt that he's a good-looking guy, which, frankly, if you're making decisions about what you think is right or wrong on whether or not someone's a good-looking person, maybe reevaluate your life. Just saying. But, that's where we are. Well, we finished this in record time, Alice.
I think that actually shows you how straightforward the argument is and how strong of a position the prosecution has in this case. But we should answer some questions because people have come to expect that our 25-minute podcast is an hour long.
That's true. That's true. Okay, so let's see. This is an interesting question. I'm interested to see it's deep.
Oh, no. My brain's pretty
it's interesting.
fried.
I mean, I know what my answer is, but...
All right.
Okay.
Hit me with it.
This is from Giztogram, and she wants to know, what would a just world look like for you?
Wow. A just world for Brett is one in which we can all escape from jail.
No.
You can go in so many directions. I'm curious to hear what you have to say.
Well, there's a lot of ways to answer this question. I mean, as you said, you could say... a just world is a perfect world, or it's almost like heaven is a just world, but a real world is never just. I think if you wanted a definitional answer, I think you could say a just world is a world in which everyone gets what they deserve. But I will say this, I would not want to live in a just world. Because if everyone got what they deserved, then
it would be a merciless world.
Exactly. And I think there's that sort of eternal question, is mercy opposed to justice, or does it go hand in hand with it? Is a deeper understanding of justice include mercy, and how does all that work? I mean, it's a great question, right? I think it's a platonic ideal. It's a world that doesn't exist and will never exist.
I agree. In this current fallen world, there's not a perfectly just world, but I'm going to say a very, predictable thing for me to say. In this fallen world where we cannot achieve perfect justice because we are flawed and a deeply broken humanity, which is okay in the sense that it's okay because that's the state of the world, and whatever you believe, I believe that this is not the end all be all. But a just world in this broken version of the world is law and order, is that there is consequence for actions, so that you cannot walk up to someone and shoot them in the head, no matter how just you believe that killing to be. We do not believe in assassinations like that. So coming from a prosecutor, I don't think that's that surprising, but I would say that there are consequences for your actions. Now, when I say the consequences for your actions, it does leave a little bit of space for that mercy, because when we go into court, I don't always just argue for the top of the guidelines. It is based on those circumstances. For if there's a lot of mental illness, for example, there, I don't think that person should be out there committing yet another murder. But I also don't necessarily think spending, life in prison with absolutely no mental health care is going to be helpful either. And so I think that's when, the devil is in the details, but more kind of largely, if you zoom out, 20,000 foot level sort of thing, it would be that there are consequences for your actions, and that there is a set of order that we as a society has decided upon. And when you break that law and order, there are consequences to it. And it is the same for everyone, no matter who you are. So I guess you could say that the reason I'm a prosecutor is I think our judiciary system attempts at its ideal to reach justice, because it is supposed to be justice is blind in our courts. It doesn't matter if you're rich or poor. If you break the law treats you the same.
I love these questions because I just think these are discussions we need to have. I feel like we're sort of a society of received wisdom. Like, we do things the way we do because it's the way we do things. It's just, that's the way we do it. And I feel like this is probably not true. This is probably an idealized version of the past. But it certainly seems like people in the past struggled with this stuff more. They grappled with it more. They really thought about it more than we do now. So I always appreciate these questions. It's funny. I always think of this group. I don't know if it's just in Alabama, maybe it's other places. It's called Vocal. Are you familiar with VOCAL, Alice? VOCAL means victims of crime and leniency. And I always thought that was so fascinating. It's like they're like a pro-victims group, but it's not just the criminals. It's also like, the judges or the prosecutors or the laws that allowed these people to continue to perpetrate violence on others when they shouldn't have. I always just thought that was a really interesting name for a group. And it sort of goes to this question. Okay, let's answer one that's less deep.
Sure.
Can we answer one that's less deep? We got time to do less deep.
Yeah, like your favorite kind of meatloaf sandwich.
There you go.
Which was a great question.
That was a good one. What kind of Jello shot are you? Okay, let's see. All right. You've already answered this question, I think. I don't know if you've... I'm going to ask it.
Okay.
If you've already answered it, I don't know if I've answered this question yet, but I definitely know the answer. Okay. So this is from Unsolved Couple Pod. Hope the podcast is going great, Unsolved Couple. And they want to know, what is the worst date you've ever been on?
Here's the thing. I have multiple really bad dates, so I could tell a different story, but I'd love to hear yours.
Yeah, so when I was in college, I went on a couple dates with this one girl. And it's so funny because, like, our first date was great. She was awesome. Really enjoyed spending time with her. And then I go out on the second date with her, and it was the weirdest date ever. We go to this, like, sort of nice, like, Italian place. And I had this whole thing set up, right? Like, and I learned a lesson from this date, too. So,
this is that's so romantic, by the way.
So people, I always remember... Everybody always just or at the time, I don't know if people do this anymore or not, but at the time, everybody took their dates to movies. That's just what you did. You just took girls to movies. You went and saw a movie, right? Okay. Well, that's great, but...
You don't really get to talk much.
You don't get to talk much. You're just watching the movie for 2.5 hours or whatever. I mean, you enjoy the movie. It's fine. Great, whatever. And so I'm thinking, I want to do something more creative than that. So, like, my plan's like, we're going to this nice Italian dinner, and then we go to this, like, cool place that's, like, on the side of a mountain that sort of overlooks the city, and it's, like, beautiful when there's sunsets. And I'm, like, thinking, this is going to be great. So we start off with the Italian place, and I don't know if she was just in a bad mood or whatever, but, like, it was just the whole thing was weird. And at the end, I got, like, what was left of my meal to go and paid, and I stood up, and she just sat there just looking at me. And I was like, is everything okay? And she just didn't say anything. I'm like, are you all right? Didn't say anything. And I'm like, what is going on here? And finally, she stands up and she points. And I look down and she's pointing at, like, the box with the food, which I had not picked up because I had forgotten that I got it. And I looked at her and I looked at the box and I picked up the box. And then she just, like, made this noise and then, like, walks off. And I was like, okay, that was weird. So then I like, follow her out, and I'm like, I don't know what's going on there, but, we'll go to the pretty place with the sunset and maybe it'll all be great. We go to the place and we're sitting there and the sun's setting and it's beautiful and she's obviously miserable. And at some point, as the sun's setting and we're sort of sitting there in silence, she goes, I wish you'd just taken me to a movie. And I was like,
wait, what?
Wow. This is what I get.
Like, mean.
This is what I get for trying to be
nice.
Whatever.
Like, I'm
And Mrs.
sorry.
Brett doesn't let me live this down because we had started dating at this point. Like, I was dating like a lot of different people.
You went on a date with someone else after
I had like 5 girlfriends at this point and was dating a lot of different girls because I was trying to find
You
Mrs.
deserved
Right.
this then.
and she's probably watching this right now thinking like, yeah.
I wish you would have taken me to a movie. I'm sorry, ladies. We're not like that.
And so the worst part of it was, it's not really the worst part of it, but so she was in a sorority. I was not in a fraternity because I didn't do fraternities, but she was in a sorority and she'd invited me to go to this, like, party the next night. So I was her date to this party. And, like, after that, I never wanted to see her again, but I had to go to the party.
Right.
And
because
she
those
had
are like,
to take me.
Those are like proms,
They're like,
right?
yeah,
like,
it's
they're
like a
like
big
nice
deal.
events.
So it was the most awkward thing ever going to this party. And, like, once we got to the bar, I went one way, she went the other way. We never spoke to each other again. It was wild.
I don't know why she would act like that, especially knowing the next night she has to take you to this, like, social, I'm sorry, that might be on her. I don't know her, but that might be on her. Okay, I'll tell you a really quick, different terrible date story. So, this was a first date. And so this guy was like, can I take you to a movie? There you go.
There
and
you
I was
go.
like, sure, we can go to a movie. And he was very like nervous about it. I was like, whatever, super low key. We're going to the movies, like no big deal, right? And so I was in school, but I was home for like the holidays. And so he like drove to my house, very nice, and like picked me up for the date. So nice. Like, people even do this anymore. So he's clearly nervous. And he's like, so it's like, he already bought the tickets online, Fandango. I was like, oh, look at this. Like, we don't have to wait in line. Like, this is great. This is very nice of him. And so, he picks me up, and because I'm home, for the holidays, he says hi to my dad. And I'm like, okay, this is awkward because I'm like an adult. This is kind of weird that he's like saying hi to my dad. So I'm like, okay, bye. So we get in the car and we drive to the movie theater, which is, like 10 minutes away. We don't talk much because this is like a first date. It's kind of, a little awkward. So we go in, and he was like, so I picked this movie because I think you're going to love it. And I was like, oh, great. I don't know that you know me that well, but
My
okay.
mind's going in so many different places, but we'll see if it went to the
man.
right place. Look at it.
And he's like, because we went to school together, so he knew I was like, I danced. I was in a dance company. I performed. So a lot of people knew that I danced. I did ballet. I danced professionally in different shows. So he was like, this is a movie about dance. And I was like, awesome. Like, what guy wants to go see a movie about dance, right? Like,
Okay.
that's thanks. That's like really nice of you. I was like, oh, okay, that's nice. And so we sit down, and the credits, I mean, not the credits, like, it's like the trailers. And I actually don't know anything about this movie because it was finals season. So I'd been studying for finals. I hadn't watched TV. I didn't know anything. So I was like, oh, okay, well, look, this is great. It's a movie about dance. I loved Step Up. I loved, Save the Last Dance. Yeah, this movie's going to be great. So we sit down, and the trailers come on. And those of you who've watched movies before know that the trailers match usually the tone of the movie you're about to watch. So if you're going to go see a Pixar movie, it's going to be like cutesy kids trailers, right? And so the first trailer that comes on is like a real creepy, like, horror movie. And I was like, this is not my scene. I don't like horror movies. You know this. All of you know this. I don't like anything remotely scary. And I'm like, all right, maybe it's just, getting you revved up to do some dance battles. And then like a second trailer. It's like pretty scary crap, I was like, okay, it's going to be fine. It's going to be fine. I'm also not going to make a big deal of this because like he doesn't know how freaked out about like scary movies I am. So like, don't be a weenie. Just, grin and bear it. And then the movie starts. He had taken me. And by the way, there was no one in the theater. So that may have been a sign that there was no one in the theater. This is not a popular movie, apparently. He had taken me to see the not award-winning, hyper psycho erotic sexual drama Black Swan.
Black Swan did win awards. Thank you very much.
It did win awards.
I loved Black Swan. I knew you were going to say Black Swan.
I also ended up liking Black Swan, but I had
you're
no
right.
concept
Yeah.
of what this movie was about. And it is like, for going on your first date with someone who you've barely really even had a conversation with, and you're both staring straight ahead as there are a lot of like psycho erotic dramas happening in front of
Awesome
you,
scenes in that movie.
is pretty intense, right?
Natalie Portman won an Oscar for that movie.
She did. Look, she did phenomenal in that movie, but I couldn't think about that because all I could think about is there are a lot of naked scenes happening, and I've barely even like held this guy's hand. And this is super awkward. And then I married him. So, and I don't let him live it down that he took me to see Black Swan as our first date.
That's hilarious. Oh, wow. That was a great reveal at the end there, Alice. That was awesome.
Thank
That
you.
was fantastic.
See, not all bad dates end badly. By the way, he was mortified. He had no idea that's what the movie was about.
I bet.
Now, you know him, so you know how mortified he is. For what it's worth, we left there and didn't talk to each other. We did not talk to each other on the whole way home. This is like a night movie. He took me home, and then he called me the next day, and he was like, do you want to try first date again? And then he took me to the Georgia Aquarium.
There you
and
go.
it was wonderful.
Georgia Aquarium. That's a much better. Much better. Much better. That's awesome.
Anyways,
there you go.
great Great question.
Yeah,
well,
great
you
question.
guys,
Thanks
thank
for
you for hanging with us. And we'll continue to follow this case, of course. And if you don't know, you can leave a 5-star review and ask any question. You can see how widely varied these questions are, and we love them. You can reach out to us at prosecutorspod@gmail.com and on all of the social medias. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. It was clear he was evading. They could, this is ridiculous.
The whole thing's ridiculous. But
This whole thing is ridiculous, but the fact that they knew it was him, you know what I mean?
oh, yeah. The probable cause thing is there's no
I know.
issue there.
It's fine. It's fine.
Hello.
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 Hello. Okay, I have to think of a... I'm not going to be offensive. I'm not going to use that descriptor.
Now I want to know. That's okay.
With all the best movies. The holidays are brutal, so if you're feeling frugal, stream Pluto TV. Stream Pluto TV. Stream Pluto TV for free. Stream blockbuster hits like 21 Jump Street, Ted, The Expendables, and so much more on Pluto TV. Stream now, pay never.